All right, our next case on the calendar is 24-523 Cedarbrook Residential Center versus North Carolina Department of Health and Human Services. You ready? You may proceed.
Good morning, Your Honors, and may it please the Court. My name is Graham Whittington. My colleague Joey Ponzi and I are with Brooks Pierce, and we represent the plaintiffs in this matter. I'd like to reserve 5 minutes for rebuttal. This case gives this Court another opportunity to reaffirm the foundational principle under North Carolina law that where there is a right, there is a remedy. That rule applies with great force when citizens suffer devastating and baseless harm at the hands of the state. That is what this case is about. Our client, Cedarbrook, is an adult care home in western North Carolina. It provides housing and treatment to residents who suffer from various disabilities. For that population, Cedarbrook is one of the few housing options available. Cedarbrook is regulated by the defendant, DHHS. For years, the defendant consistently gave Cedarbrook positive reviews. That changed dramatically and without cause in late 2015. As detailed in our complaint, defendant found violations where none had existed previously and bombarded Cedarbrook with a series of devastating penalties that had no basis in reason or fact, and that caused our clients more than $1 million in damages. To remedy that harm, in 2018, we pursued claims previously available to us. Those claims were eliminated by the Supreme Court's ruling in Cedarbrook 2. After Cedarbrook 2, we resorted to our last and newly available remedy, our quorum claims here. Now, quorum claims are an extraordinary relief available only in limited circumstances. The limited availability of those quorum claims drives the two primary questions before the court today. First, did our quorum claims accrue when they became available due to Cedarbrook 2? And second, and alternatively, does equitable tolling apply under the circumstances of this case? Because plaintiffs should prevail under either theory, the trial court's dismissal was an error. And I'd like to address accrual first. In short, our quorum claims here did not accrue until Cedarbrook 2 made them newly available.
So let's talk about the Supreme Court's opinion in Cedarbrook 2. It certainly doesn't describe itself as this change in the substantive law, does it?
I think it does not. And if you're referring to that opinion's discussion of the prior cases that we have discussed in briefing throughout the course of Cedarbrook 2 that we referred to in this case, I think you'll note that the Supreme Court is pretty clear that it thought those cases were irrelevant to its decision in Cedarbrook 2. I looked at Black's Law yesterday. If a discussion is not essential to a decision, then it's dicta. Dicta from the Supreme Court can be persuasive, but it's not binding on this court. And so we are going to point to a number of cases. We're going to point to Chief Justice Newby's dissent that Justice Berger joined as other persuasive authority to look back to see in 2018, when we filed our State Tort Claims Act claim, was that the available remedy to us preclusive of quorum claims?
There was, of course, a third remedy, and that was the administrative procedure, the process that had occurred even prior to bringing the State Tort Claims Act.
Yes, Your Honor. So that was Cedarbrook 1, and that was a remedy to stop the harm. That wasn't a remedy for us to get damages from the harm caused. And so I think that was its own own case essentially, and then there was a subsequent case where we were seeking remedy for the harm that the state caused us.
So there's no provision for damages under the API in this type of case, correct?
No provision for damages. There were attorney's fees, but that obviously goes to the attorney's fees incurred in the course of those proceedings. That doesn't go to damages that were caused by the acts of the defendant. And
just so that I'm clear, when you were before the Office of Administrative Hearings, I understand that the case settled the day of trial.
That's right.
So it wasn't merely that they withdrew everything and just cut off what they were doing. There were certain concessions on both sides. Am I correct about that?
My understanding is that we agreed not to pursue attorney's fees, but otherwise there was no release. And so,
but as far as actions that you were going to take to remedy I think, certain underlying issues that there were. Is that, from what I understand from the opposing side's brief, is that it wasn't just they're going to stop and go away, but there were actually concessions on your side or remedies that you made for some of the charges that they had.
I don't know if that's a remedy we made. I think we just didn't pursue the attorney's fees, which don't go to damages.
Okay, so you're I guess saying that the only thing that you did in exchange for them going away was agree not to go after attorney's fees.
That's my understanding. Okay. Yes, that preceded my time on the case. But in any event, so going back to Judge Hampson, your question about Cedarbrook 2. So again, the Supreme Court made very clear its discussion of those prior cases distinguished them, said they were irrelevant. So we think that's dicta. Dicta is not binding on this court.
Well, in part, wasn't that because the court was saying this sort of like negligent regulation claim doesn't really apply to those being regulated?
And I think we can point to a few cases where that had not been found. And Chief Justice Newby refers to some of these in his dissent. So we would point you to that for a pretty succinct analysis of it. But three important ones we'd point you to are Russell, Watts, and Crump. Those are cited. Would you like citations for those? Okay. So those are three permitting cases where the regulators were found to be negligent, undertaking regulatory acts that were geared towards the regulated parties. In those cases, the folks who were applying for permits. Those preceded our filing of Cedarbrook 2. It was our view that given the circumstances of those cases and other cases that also had found that regulators could be negligent for undertaking regulatory acts, that we had to go with this option under the State Tort Claims Act, which would have been preclusive of our quorum claim. You'll note as well, Nanny's Corner, as they have pointed out, that came after the Court of Appeals decision, came after we filed our complaint here, but you'll note that briefing had been underway in that case. The state had made pretty clear that the type of negligent regulation claim that we brought here was available under the State Tort Claims Act, and it precluded the quorum claim. Now, I think they've referred to the fact that we maybe could have tried to stay the case in Superior Court had we filed the quorum claim, but it's important to note that quorum claims are a bit unusual in that they're subject to immediate dismissal if there's a coextensive adequate state remedy. And that's in fact what happened in Nanny's Corner. They chided the other side for trying to hedge their bets with their State Tort Claims Act claim by filing the constitutional claim. And so there's no reason to think that that wouldn't have gotten dismissed in our case. So
in this case, the trial court dismissed your claims because of the statute of limitations, that there's a statute of limitations that constitutional claims on these civil actions are supposed to be brought within 3 years from the date that they accrue. And so the trial court said you didn't meet the statute of limitations. Why is the trial court wrong?
I think the important point there is actually when the accrual occurs. And so often the accrual occurs with the injury. But there's also a lot of case law out there stating that the accrual occurs when the claimant is able to bring the cause of action. In our case, given the nature of quorum claims, they're precluded if there's a coextensive cause of action that covers the same remedy. The quorum claim was not available to us and thus did not accrue until Cedarbrook 2 eliminated the State Tort Claims Act claim that previously had been available to us. And I think it's helpful to maybe take a step back to see, that speaking of the unusual nature of quorum claims, the unusual procedure here as well. So State Tort Claims Act claims have to be brought before the Industrial Commission. Quorum claims have to be brought in Superior Court. So we had mutually exclusive claims that had to be brought in separate forums.
But we do know that, going back to Cedarbrook 1, the administrative Office of Administrative Hearings case, we know that you're permitted to bring a constitutional claim in addition to the administrative claims. So the constitutional claim could have been pursued at that point.
It's my understanding that quorum claims come through the state courts. That's the law that I've seen. I don't know if that issue was briefed in this case, and so I'm not sure that we haven't addressed that here. My understanding is that the quorum claim needed to be brought in state court, which, Superior Court, which is, obviously going to be precluded in the Industrial Commission. So if you're thinking about, I guess, the reach of this accrual rule, we think that this would have limited reach if the court were to agree with us. And again, that goes back to the unusual circumstances here, different forums, mutually exclusive claims. So no, it's not going to be a situation where every single change of law is going to result in new accruals. So just by way of example, taking one end of the spectrum, let's say you have contract claims, quasi-contract claims. The Supreme Court decides we're done with unjust enrichment, you can't bring those claims. Because those can be brought in the alternative, that's not going to strike up a bunch of accruals for breach of contract claims. On the other end, I think a good example would be the Workers' Compensation Act. So that's a law where if you are injured at the workplace and you want to sue on that injury, your sole recourse is through the Workers' Compensation Act in front of the Industrial Commission. You cannot bring a coextensive negligence claim in Superior Court. That would be subject to immediate dismissal. If the Supreme Court were to rule all of a sudden the Workers' Compensation Act is unconstitutional, we're eliminating that option, that might leave a whole lot of litigants who are currently pursuing Workers' Compensation Act claims from having recourse.
But there we'd have a clear ruling from our state Supreme Court saying the Workers' Compensation Act is no more. Mm-hmm. That's not really what we have here. And I think one of my concerns is we sit as the intermediate state appellate court. Are you asking us in the first instance to read Cedarbrook 2 and hold that it was a fundamental substantive change in the law when nothing in that opinion says it was that? And that, I suspect the Supreme Court might argue, well, this was a decision based on the allegations that y'all have made in your complaint related to the regulation of Cedarbrook.
So we're not asking you to go against the fundamental holding of Cedarbrook 2, which is that negligent regulation claims are no longer actionable under the State Tort Claims Act. Again, the portion that we are focusing on here is the dicta. And I understand that's persuasive authority to this court. It's going to have a fair bit of weight, but it's not binding. And so we would ask that you consider that in addition to the cases we've referred to that speak for themselves in Chief Justice Newby's dissent to assess whether in 2018 we had that claim available to us. And Your Honor, I think now would probably be a good time to turn to the equitable tolling argument, unless you have further questions about accrual. Okay. So we've provided the court with a number of decisions relating to this. I'd like to take them in different batches. I think the first one I'd like to lead off with is the House of Rayford farm case that we provided the court in our memorandum of additional authority on Friday. And so the upshot of that case was the Supreme Court decided that the statute of limitations was told when the trial tribunal exercised subject matter jurisdiction over the case erroneously. We think that applies with great force here. So in that case, the plaintiff had been penalized by a regulatory agency and it wanted to contest those penalties. It should have brought that contested claim before the Office of Administrative Hearings, but it brought it in Superior Court. The state moved to dismiss that. The court nevertheless exercised subject matter jurisdiction over it. That got appealed up to the Court of Appeals and was ultimately sent back down. The Court of Appeals agreed, no subject matter jurisdiction here. The problem for the plaintiff in that case was that there was a 60-day statute of limitations, essentially, to contest the penalty. By the time they got remanded in the first case, that 60 days was far gone. Plaintiff tried to pursue the claim before the Office of Administrative Hearings. That was dismissed as time barred. That issue made its way up to the Supreme Court. Supreme Court held, even though the plaintiff was the one that affirmatively filed and mistakenly filed that action before the Office of before the Superior Court, it was the Superior Court's erroneous exercise of subject matter jurisdiction that caused the issue, and that told the statute of limitations for the plaintiff. And we think that either controls here or at least is extremely persuasive in this setting. Second, I'd like to turn to a number of cases we cited in our opening brief. The lead case in that was Bryant. I believe the defendant here said that that was the only case we pointed to, although we cited about a dozen cases standing for this equitable tolling doctrine that we are urging the court to take up. And those cases range federal court, levels of state court, many different areas of the law, and they all can be distilled into this analysis of equitable tolling being proper when the plaintiff had been diligent in pursuing its rights and claims in a prior action. There was an extraordinary circumstance, such as a change in the law or even confusion in the law, and the defendant had timely notice and no undue prejudice would result. We think that that is pretty squarely our case here. We previously pursued our claims. I think in the accrual setting, Judge Hampson, I think there probably is going to be a harder decision about whether there was a change in the law, but in equitable tolling, even confusion in the law can be the type of extraordinary circumstance that would permit for equitable tolling to apply. And I think it's hard to say that there was no confusion in the law when the Court of Appeals twice agreed with the position that we had taken, Cedarbrook 2, that we had this negligent regulation claim available to us. Moreover, the defendant has long been on notice of our claims. The prior case lasted a long time. I'm assuming that they put in place their document retention policies and otherwise have preserved witnesses because they had their obligation to do that through the course of Cedarbrook 2. We turned around and quickly filed the quorum claims here, and so we don't think there would be any undue prejudice to the defendants if this claim were to proceed under an equitable tolling argument. I'd like to now turn to a couple of other cases that we provided in our memorandum of additional authority. One is the Aikens case from the Fourth Circuit. So that court undertook a thorough analysis trying to determine whether our Supreme Court would take up the equitable tolling theory that we're advocating for in this case. I essentially laid out the analysis for that equitable tolling theory just now, and we would urge the court to find that the Fourth Circuit's analysis there was correct. And I'll note too, Your Honors, that this court's recent decision from September in Kinlaw took up that approach. It cited the CTS court decision that we cited in our brief, and it found that this extraordinary circumstances test, where you're taking into consideration the facts and circumstances of the case, can apply under North Carolina law. I'll note too, I believe DHHS briefed that as though that is the law. I don't know if they're going to change their mind in this case, but it seems that we have taken up now what Aikens suggested we take up, which is this extraordinary circumstances equitable tolling analysis.
I want to ask a bit about, you're asking us to take judicial notice of a brief in a different case, correct? In Annie's corner of the state's brief.
Yes, Your Honor.
That does not seem to have been done before, although you seem to have cited cases where they do it. I understand citing a brief in the same case, perhaps in a lower court proceeding. But it's your argument that we can actually judicially notice a brief from an entirely different case.
My understanding is that it's part of the public record, and so yes, I believe you can.
So, and there are lots of things that are part of the public record. Can we just judicially notice everything?
I don't know what all we're referring to with everything, and I'm not trying to be cute there, but I think that with court records, we are a court.
But that's not a court record. That is a brief filed by a party, correct?
Before the court, yes. And okay.
I guess what you're asking is that we are requesting is that we take judicial notice of that brief, not for the purpose of necessarily the truth or falsity of anything in there, but for the fact that a particular argument has previously been made before.
Yes, Your Honor. And I don't think that the briefs are going to be case determinative in either instance. And so if you consider them or not, I think that our arguments still hold weight here. But we ask that you consider them under judicial notice. And I'd like now to turn, sticking with equitable tolling, I'd like to turn to the cases that defendants cited. They cited Town of Pineville and Vanek. And those were Court of Appeals cases that stand for the proposition that equitable tolling applies when defendant has undertaken some kind of misconduct or act that caused the plaintiff to delay filing their complaint. Aiken has a pretty good analysis of these two cases and the lineage that they're part of, but I'd like to direct the court to a couple of the cases discussed in Aiken's, which are Knoll and Steinbeck, cited in the Aiken's case. Those are two cases where the court, these are North Carolina courts, specifically said equitable estoppel, not equitable tolling, they never mentioned equitable tolling, equitable estoppel can apply to essentially eliminate a defendant's statute of limitations argument if the defendant created the kind of misconduct or mischief that caused the plaintiff to delay filing the complaint. Town of Pineville and Vanek later take that up. They end up using equitable tolling terms. I think one of them honestly goes back and forth. I believe it titles their section equitable estoppel and then talks about equitable tolling. But Aiken's makes pretty clear equitable estoppel is sufficient for equitable tolling, but it's not necessary. It is just one way you can get to equitable tolling. The other way is through the extraordinary circumstances test that's discussed in length at Aiken's, and that is employed in the Kinlaw decision. And we ask the court to take that up here and find that plaintiff previously diligently pursued its claims. There was some extraordinary circumstance, whether it's a change in the law or understandable confusion about the law, and that the defendant was put on notice and is not going to be unduly prejudiced. And now, Your Honors, I would like to briefly address the defendant's claim splitting defense. As discussed previously, we had to bring the State Tort Claims Act claim before the Industrial Commission. The constitutional claim at that point would have had to be before the Superior Court. There's just, to us, no conceivable way that the claim splitting theory here could apply.
And did the trial court base its ruling here on claim splitting, or is it your contention that the trial court's decision, which we're reviewing, was based entirely on the statute of limitations defense?
So I think you'll notice the order itself was pretty succinct. I believe the defendant pointed towards the trial court's closing statements at the end of the hearing. I would say the hearing transcript wasn't the clearest in terms of determining what all the court took into consideration. And so, there are a number of things. They pointed out, for example, that they didn't brief or argue at the hearing res judicata. They moved to dismiss on that basis. And so we covered all bases just to be safe. They briefed claim splitting before you. And so my presumption is they agree res judicata doesn't apply, but they think that claim splitting does. I'm assuming that they believe the court took up the claim splitting argument since they briefed it. I'll let them speak to that though. But in any event, we don't think the claim splitting argument that they present can apply here. And unless the court has any further questions, I'd like to save the remainder of my time for rebuttal. Thank you.
Good morning. May it please the court. I'm Adam Dorr with Robinson Bradshaw. I'm here with my colleague, Uzoma Owete, on behalf of the North Carolina Department of Health and Human Services. As the court knows, this is the third appellate argument in this dispute on top of two arguments in the Industrial Commission. We argued it at Wake Forest Law School 3 years ago, and then before the Supreme Court in a special session in Edenton 2 years ago. And our position is that the time has come to bring this litigation to an end. Cedarbrook's claims are quorum claims. The statute of limitations that applies to such claims is 3 years. The parties agree on this point. There's no dispute about that. The events that gave rise to Cedarbrook's claim occurred in 2015 and 2016, and this case was filed in 2023.
So it's your contention that in 2018 they had the ability to bring a constitutional claim?
Yes, that's
where?
They could have either filed a constitutional claim in Superior Court, or they could have filed it along with the Industrial Commission as an alternative argument and then raised that when it came up to the Court of Appeals, which would have jurisdiction.
Do you agree that were there a viable State Tort Claims Act that would preclude a quorum action?
Yes, if there was a viable State Court Claims Act, it would preclude a quorum claim. The problem with that argument is that by delaying and choosing not to file the constitutional claim up front, Cedarbrook prevented both of those claims from being presented to the courts for a resolution in a way that made sense. And in fact, as you raised, Judge Hampson, when they actually could have filed the constitutional claim earlier during the administrative proceedings. And in fact, that's what happened in the Nanny's Corner case, which plaintiffs rely on heavily, is that there was administrative proceedings, and then those went on for a while, went up to the Court of Appeals. The Court of Appeals issued a ruling, and then Nanny's Corner proceeded to file a tort claim in the Industrial Commission and a Superior Court action for the constitutional claims at the same time.
Well, didn't the state then argue that because the constitutional claims had to be dismissed because Nanny's Corner had an adequate state remedy under the State Tort Claim Act?
Yes, that argument is found in the brief, which is included with the filing by the plaintiff's counsel.
And wasn't that the existing law at the time?
No, it was not the existing law. At least that's our position. And the reason that it was not the existing law, as the Supreme Court found, is that all of the cases that Cedarbrook viewed as finding a claim similar to its were all distinguishable. So even the cases that they're raising today, Russell, Watts, Crump, those cases are expressly distinguished in the Supreme Court's opinion in Cedarbrook 2, and where it says that those cases don't apply to the kind of claim that Cedarbrook is attempting to bring. I guess the other point about the Nanny's Corner case is that Nanny's Corner was primarily a statute of limitations case, just like this one. And what the court held was that the quorum claims were time barred because Nanny's Corner had failed to bring those claims within the statute of limitations starting from the administrative proceedings. And then that was the date of the injury. That was when the claim accrued. Therefore, it was untimely. At the same time, Nanny's Corner was also trying to pursue its tort claim in the Industrial Commission, and the Industrial Commission held that that claim was untimely. So by the time it gets to this court, both cases have been dismissed as untimely. And so the statute of limitations is the key part of the case, and the court says basically the statute of limitations decides the issue, but we're going to proceed to address this question of the negligence claim as well. So the core issue here is that Judge Davis did not err in determining that Cedarbrook's claims are barred by the statute of limitations. As he put it in hearing, the statute started to run, and it's run. I don't think there's any lack of clarity about the basis for that holding. He says, I'm going to allow your motion to dismiss based on the statute of limitations on a constitutional claim. I see no. It started to run, and it's run. And then he goes on to this idea that when the Supreme Court decided Cedarbrook 2, it was not changing the law. It was just stating what the law is. And there's this idea that I think is kind of lurking in the background of plaintiffs' arguments that really it's their subjective understanding of what the law was when they first filed their Industrial Commission claim that should determine the statute of limitations for the quorum claim. So they believed that they were precluded from filing a quorum claim, so they didn't do it. And our position is that from the very beginning of the case that was incorrect. The negligent regulation claim was not permitted, and we maintained that position throughout. In our first motion to dismiss in the Industrial Commission, we were saying that this is not a valid claim for exactly the same reasons that the Supreme Court ultimately recognized. And in that situation, it would have been prudent to file in Superior Court a claim under the Constitution, the quorum claims that they're now trying to pursue. There was nothing stopping them from doing that. And that's really what distinguishes this case from most of the other cases they cite that are involved in North Carolina law, is that there was some legal impediment that prohibited the filing. And that's
So
not
just
the case here.
on page 19 of the Supreme Court's opinion, it says, in rejecting, we're talking about Nanny's Corner, rejecting the daycare center's argument, the Court of Appeals held that the center did not have a direct constitutional claim, yet had had an adequate state remedy in the form of industrial commission through the State Tort Claims Act. It seems like all of the cases leading up to Cedarbrook 2 essentially say you don't have a quorum claim because you have a state tort claim. They all say that, and then the Supreme Court says, no, you're wrong. So does that mean all the way along that parties can't rely on what the Court of Appeals is deciding, and then we have to wait until the Supreme Court to decide what the law said the previous 6 years? Or is the law all the way until the Supreme Court says it's something different? Because it's, and let me phrase it differently, it's very difficult to rely on cases that are essentially stating the law, and then the Supreme Court says, no, it's different. And maybe that's more of the equitable remedy that we're talking about and the confusion in the law.
I guess I would say that the earlier cases don't recognize the kind of claim that Cedarbrook was trying to bring. That was our position all along, and that is what the Supreme Court held on multiple grounds. Plaintiffs' counsel would like to distinguish that as dicta, but it's pretty clear that it's an express part of the holding. For example, they say, nothing in the applicable statutory provisions or prior case law recognizes the validity of a claim like the one that plaintiffs have asserted in this case, and we hold that no such claim exists. So first of all, holding, not dicta. Second of all, they're looking at it and surveying all of these cases that Cedarbrook relied on in that case and is still trying to rely on today, and saying that those cases are not the same as the claim that Cedarbrook is. So our position is, to sum it up, is not that the Supreme Court changed the law, but that it expressly held that Cedarbrook's claim never existed in the first place.
So how do we kind of square that then with Justice Earle's concurring opinion, which kind of makes the point, in my view, the many allegations of the complaint involve intentional, not negligent acts, and thus rather than engage in the judicial nullification of statutory rights by invoking an all-encompassing sovereign immunity for regulatory agencies, this case is most appropriately resolved by the normal function the court should perform in ruling on a motion to dismiss. So Justice Earle's obviously expressing a narrower view of the case, but in so doing seems to strongly suggest that the majority opinion is in fact a pretty broadly encompassing change in the statutory rights of the parties.
I think that she is suggesting that it's broad, and it is. I don't think she's necessarily suggesting that it's changing the law, and in fact, she just would decide it on the narrower grounds of whether the department owed a duty that was enforceable in tort, and her position is, no, these were intentional actions by the regulators. This is not a tort claim. Torts involve negligent conduct, and when a regulator, inspects a facility and chooses to assess penalties, that's an intentional act. And she goes back and cites multiple Court of Appeals cases for the position that when a regulator takes enforcement action, that in those cases, that's an intentional action, therefore not a tort under the Tort Claims Act. So even though she concurs separately and agrees with holding on a more limited basis, she is also saying that Cedarbrook's claim has not been recognized in the past. She's just citing different cases that undercut it because those two earlier cases are focused on the question of intentional versus non-intentional conduct. So our position is that the majority and Justice Earle's are all saying that Cedarbrook's claim is not a claim that has previously been recognized.
And just to be clear, Cedarbrook's claim is a claim of negligent regulation, right? Versus general negligence claims under the state claims that they contend that it was the negligent regulation that led to their damages.
That's what they claim, yes. Their claim was specifically listing the regulatory actions the department took against it and saying that the department was negligent in taking those regulatory actions. And that's the way that the Supreme Court characterized the claim.
Well, one of the differences here is that the allegations are that the agency was being overly heavy-handed in how it regulated Cedarbrook, as compared to cases where the agency had not regulated properly, which led to patients escaping and dying and those sorts of things. Here it was the agency was too heavy-handed in how it regulated.
Yes, that was one of the multiple distinctions that the Supreme Court found. In addition to the fact that in most of the other cases that Cedarbrook was citing as evidence for this negligent regulation claim, the plaintiff in those cases was somebody who had been injured by a regulatory failure, right? So people who were in a jail where the smoke detectors hadn't been inspected properly, there was a fire, people died. And so that was one of the reasons that the Supreme Court distinguished those kinds of cases, is that it was saying those aren't a claim where the regulated party is trying to sue its regulator in tort. Those are situations where people were injured because the regulators weren't doing their job. That's a different kind of negligence.
I guess on the other hand, your colleagues argue that there are cases in which the regulated party was permitted to bring that type of action. How do you address those cases?
I think the Supreme Court addressed those cases, specifically all of the ones that they cite. I think the only case that comes close to recognizing that, as the Supreme Court noted, was the Nanny's Corner case. And that's where the Supreme Court says, yes, it appears to recognize this, at least to some extent. It wasn't the primary issue in the case, but to the extent that it suggests that this is a viable claim, it's overruled. So our position is that even if there was a disputed question of law about whether Cedarbrook could bring a tort claim in the Industrial Commission or was required to file quorum claims, that kind of open legal question happens all the time. And when it's resolved in one way or the other here, unfavorably to Cedarbrook, that doesn't give rise to a whole new cause of action. Because that's really what Cedarbrook's claim is grounded on here, is the idea that this Supreme Court case is what started the running of their quorum claim. And there's just no support for that in North Carolina law. And there are many good reasons not to hold that that's the case, in particular because it would allow parties to sit on claims, do what Cedarbrook did here, file one claim, wait for that to be resolved against them, and then come back and file a whole new claim based on the exact same facts that happened now many, many years ago, and try and start over again rather than just presenting it all together.
What seems interesting, the verbiage of Cedarbrook in the North Carolina Supreme Court says, although we did not fault the Court of Appeals for relying on Nanny's Corner in Cedarbrook 1 as binding precedent, we also do not, following a more rigorous analysis, find Nanny's Corner to be persuasive, and for that reason overrule it to the extent it conflicts with this opinion. So reading that, one couldn't fault a party for relying on Nanny's Corner as well. If the Court of Appeals isn't faulted for relying on that, how can the opposing party be faulted for relying on that until the Supreme Court said otherwise?
I don't think that we are trying to fault them for that. I think we're just trying to say that the cause of action accrues when the injury occurs, which here is 2015 or 2016. And they had multiple options to try and pursue that on a timely basis as a quorum claim, as the parties did in Nanny's Corner, as the parties did in some of the other cases that they cite. I mean, it shows up in a number of the cases cited here that there's a simultaneous proceeding in the Industrial Commission and a quorum claims on it. And so in that scenario, our position is you can't just wait to see if your Industrial Commission claim plays out and then only file a quorum claim later. You need to present both on a timely basis.
Well, can you give me a cite to one of those cases that you're talking about? Because I think the North Carolina law is very clear that if a litigant has a remedy under a state law, they cannot bring a quorum claim to redress the same injury and seek the remedy. And I mean, I think Washington Klein, quorum versus UNC, I think those are all very clear that the parties just cannot do that. So which cases are you referring to?
So yes, that's certainly the case in Nanny's Corner. It's also true in Pate versus NC Department of Transportation. And it's also true in Taylor versus Wake County. In fact, Cedarbrook recognizes that in its brief at page 13, talking about Taylor versus Wake County, it acknowledges that that case involved simultaneous quorum and industrial commission claims. So, if we're going to look at this from the subjective perspective of the party deciding whether to pursue a quorum claim or not, there are numerous examples out there of other parties doing that, and and that's an important thing to do to avoid the statute of limitations. I guess the last point I would make is, this court and the Supreme Court has been dealing with a number of constitutional claims lately. I believe, Judge Wood, you've authored several of those decisions. I mean, those are cases that were initiated before the Supreme Court's ruling in Cedarbrook. They're bringing constitutional claims of the same kind asserted here, law of the land type claims or fruits of our labor. But those parties didn't seem to think that they needed to file a Tort Claims Act claim in the Industrial Commission. They proceeded with the quorum claim. And we think that, the function of the claim splitting argument here, I agree that these couldn't have been filed necessarily together. But the point of the claim splitting doctrine is that you need to present all of the issues up to the court to decide in a cohesive manner. And that's what could have happened here. And it would have been much better if it had. So if, Cedarbrook is saying that they couldn't file their claim in Superior Court because it would have been subject to immediate dismissal, or maybe that they would have been subject to Rule 11 sanctions. I don't think there's any support for that position, and I don't see how they could be subject to Rule 11 sanctions if we are taking the position that, that their Tort Claims Act claim is invalid, right? So, but putting that aside, if they had done that, it would have required the department to respond and take a position. Either the department would have said that there is no quorum claim here, or there is no tort claim here, and there would have been a dynamic between the two claims rather than presenting them serially as happened here. And so that's kind of where the idea of the claim splitting comes in. It's not a part of the trial court's holding, but it is consistent with principles of North Carolina law that you want to present all the claims at the same time so that the courts can decide them together.
So you're not saying true claim splitting, you're saying it would have been better.
Yes, and that's consistent with the policies underlying this claim splitting doctrine. But again, the court doesn't need to reach any of that to decide the case. It's a very clear application of the statute of limitations in our view. Unless the court has any further questions.
No, thank you.
Yeah.
Officer, how much time? 7? You have 7 minutes for your rebuttal?
Thank you, Greg.
No.
I'd like to address a few points that they raised, and I think I'm going to start with accrual again. Chief Justice Newby couldn't have been clearer in his dissent. The court's decision in Cedarbrook 2 was a change in the law. It removed the State Tort Claims Act claim from us. And I think Mr. Dora raised a point that case law could result in a change in the law, or is it just a clarification of what the law really was? I think it's helpful to look at a lot of the equitable tolling cases that we have cited to that effect. They make clear that even the overruling of a decision, case law, can be a change in the law. And I think describing the overruling a precedent like that as just clarifying the law instead of creating a change in the law ignores the time trap that Cedarbrook 2 ultimately created for us. We filed our claims in 2018 under the authority available to us then, believing that the State Tort Claims Act was available to us, preclusive of quorum claims. Cedarbrook 2 ultimately disagreed, but that put us in this position, this time trap, where it was too late. It just put us in this time trap. So in Nanny's Corner, I'll note, I think Mr. Dorr mentioned that the quorum preclusivity issue was secondary or maybe tertiary. They led with that in their trial court brief. It was a central issue in Nanny's Corner, and I don't think a suggestion otherwise is effective there.
One question, had you filed your constitutional claims at the same time, just trying to throw it all out there? What could have happened? It could have been dismissed with prejudice, or coming.
Are you asking Superior Court or Industrial Commission? Because
Either one.
Okay, so it's our position that under the law then, it was clear that we didn't have a quorum claim before the Superior Court.
Okay.
And so, I think he said there's no basis for the Rule 11 sanctions. Rule 11 is pretty clear. If you don't have a legal argument, if there's no legal basis for the claim, then sanctions are mandatory. And we would have been going to court saying, we believe that we have a State Tort Claims Act claim. We believe that this quorum claim that we're filing before the court in its whole own lawsuit is not viable. But please, Your Honor, proceed with it as you will. We think that that could have subjected us to Rule 11 claims. And there's no guarantee that we would have been able to stay the claims to see how the Industrial Commission case played out, because staying a case, one, subject to the discretion of the court. Two, again, they moved for immediate dismissal under Nanny's Corner. And I'll note, Mr. Dorr referred to the Taylor v. Wake County case. I think that actually helps us. That was the case where they did file before the Industrial Commission and they did file before the Superior Court. You'll note that the quorum claim was first the subject of a motion to dismiss, and then 5 or 6 days later, the state moved for summary judgment, attaching the brief, or rather the complaint in the Industrial Commission, saying, look, they have filed the State Tort Claims Act claim in front of the Industrial Commission. This quorum claim is subject to dismissal, and that's exactly what happened. And so the quorum claim in that case got wiped out immediately. We think that given the law out there, there was no reason why we should have filed the quorum claim before Superior Court. It was going to be subject to immediate dismissal. And I'll note too, I think there are various judicial economy concerns at play in this case. And the approach that they're recommending for a circumstance like ours, where we have these exclusive jurisdictions, is that folks file these kind of provisional claims in Superior Court to save them in the off chance that the law changes and their other recourse is removed from them. That is going to create a burden on the Superior Courts, and it ultimately is going to create a burden on the Court of Appeals. Look at what happened in Nanny's Corner. You had the Industrial Commission case that went through its own process and reached the Court of Appeals. And then you had the Superior Court case that separately ended up going through its own process up to the Court of Appeals. And the Court of Appeals twice had to address Nanny's Corner. And so, if you're forcing litigants to file these provisional claims in Superior Court, you're going to clog the courts. I'll note too, we didn't sit on the quorum claim. We were just attempting to follow the law as we saw it at the time. Again, we believe that the law at the time required that we file the State Tort Claims Act claim, and so we followed that law and filed only that and not the quorum claim. I'll note too, I believe they said that we should have filed the quorum claim in Superior Court once they moved to dismiss on the sovereign immunity issue. At that point, the Industrial Commission denied the motion to dismiss, and they took jurisdiction of the claim. That is akin to the House of Rayford Farms issue, to the extent it was ultimately an erroneous exercise of subject matter jurisdiction, then the statute of limitations was told as per House of Rayford Farms. Just a few other points. Judge Collins, you asked about the settlement at the OAH. We made no concessions beyond the attorney's fees issue. Our operations didn't change a bit. And so operationally, Cedarbrook proceeded as though the OAH proceeding never happened. And, you know, I'll note too, there seemed to be some flip-flopping back and forth between whether we could have brought the quorum claims before the Industrial Commission, whether that was improper. We maintain that it would have been improper to try to bring them before the Industrial Commission because they would have been subject to immediate dismissal, and it would have been improper to bring them before the Superior Court. For the reasons we discussed, that claim would have been subject to immediate dismissal as well. And, Your Honors, we have just long been in search of our day in court. That's all we're asking for here. For the reasons we discussed, we ask that you reverse the dismissal order and remand this so we can finally have our day in court. Thank you.
Thank you. Thank you both sides for excellent arguments. We will take them under consideration. May I adjourn court?
All rise. This session of the North Carolina Court of Appeals is adjourned.